Instructions on how to pre-qualify for Medicaid. Why should I qualify for Medicaid now? You may be thinking, I have insurance, income, a house, and a decent savings. I can afford the deductibles and copays. Why not wait until I need it? When you should be thinking, my crystal ball doesn't work, and I have always been taught an ounce of prevention is better than a pound of cure, just in case. Eliminate risk of financial devastation, both sooner and later. What if something happened tomorrow, or in 10 years? We don't know when. What if you were wiped out with nothing for your family to inherit? Let me tell you about Daniel. He was employed with insurance from 2002 until September 2021. In 2013, he bought a house at $127,000 and then spent a lot of money to upgrade and remodel. In 2025, the value is $480K. In 2015, he separated his assets from personal ownership with the asset preservation strategies, and as an added benefit, he qualified for Medicaid if ever needed. He continued working and all was well. Good income, good insurance, a mortgage payment, the common story. October 26, 2021, at age 37, no insurance, COVID hit, on a ventilator in a coma for a week, in the hospital 2 weeks, covered by Medicaid. He's still recovering and still in the same house. You may be asking, how do I qualify for Medicaid now? The simple answer is to learn the rules and the laws that apply and comply to the letter of the law. The topics you will need to know are these: Asset Forfeiture Program, Estate Asset Recovery Program, Statutory Entities, Contracts, Look-Back Period, Fraudulent Transfer, Spend Down, Medicaid Asset Limits. These are all essential, and we will introduce you to them here and now. Let me tell you about Dave. In 2020, Dave had a very bad year with COVID pneumonia and then congestive heart failure, followed by a quadruple bypass in the fall. Dave was and still is no longer able to work. In 2021, he inherited a pickup truck when his father passed away. Book value at $8,500. Medicaid was terminated because the asset limit in Utah was $8,000. A quick audit of DMV records showed 12 titles no longer owned, no longer working, disqualifying for Medicaid. Dave signed all titles to remove personal ownership and no longer exceeded the limit. Medicaid approved and reinstated with only 1 month of non-coverage. The prescriptions alone were nearly $3,000 a month, plus there are ongoing tests, rehab, and various doctor follow-ups. Let's introduce you to the Government Asset Forfeiture Program. The Asset Forfeiture Program involves federal, state, tribal, and local law enforcement agencies across the country, with the primary goal of punishing and deterring criminal activity by depriving criminals of property used in or acquired through illegal activities. That sounds good. This is a scary one because it has been used to target the innocent as well. Sadly, this forfeiture is often inflicted on individuals without any evidence of wrongdoing, regardless of how innocent they are. There are numerous examples of citizens that had legitimate cash even in the bank envelope for legitimate and legal uses in their car when pulled over, where the cash was labeled suspicious drug money and seized. Paul decided to buy a used truck from a private party who would only accept cash. Paul went to the bank and withdrew $43,000 cash. On his way to the truck in another state, he was pulled over and the cash was seized, never to be returned. This cash usually goes to buy extra fancy equipment for the department. Welcome to how patient the government is. The reality of life is all but the super wealthy will use a Medicaid benefit sooner or later. The Estate Asset Recovery Program is built right into the Medicaid application. Basically, anyone that uses a Medicaid benefit agrees to forfeit their assets upon death. This means the inheritance is stripped from the family. They wait until someone dies when it is easier to use the court system to take. In 1993, Bill Clinton signed a federal mandate that made enforcement of the government estate asset recovery program mandatory. Medicaid uses the court system to seize more assets from unsuspecting families than all other collectors combined, including all the bank foreclosures nationwide. Houses, inheritance, and heirlooms have been lost due to a lack of knowledge. Learn how to separate and preserve assets to keep the family farm in the family. James has a family with kids and grandkids. He had a family home with no mortgage. It needed updating to sell at retail price, so the three siblings spent $52,000 from savings and credit lines to maximize their inheritance. Deferred maintenance is a real thing. The property sold for $472,000. The Government Asset Recovery Program took $472,000 minus the cost to close. At closing, the three siblings received zero. Their inheritance was lost, and the siblings' investment of $52,000 was lost, and their time and labor was lost. The government will wait until someone dies and use the court system to take their assets. The reach and limits of the court must be contained within the rule of law. You need to learn and use the law to protect yourself, or someone else will use the law against you. Your knowledge implemented is the limit to the court's reach. Keep in mind that 1. LLCs, S Corps, C Corps, partnerships, etc. are public entities. 2. Living trust, grantor trust, and any form of revocable trust can be forcibly revoked by court order. 3. There is a look-back period, which means the court can look back 5 years on all asset transactions. And 4. That fraudulent transfer can have a criminal charge. Let me tell you about Bill. Bill has a third-generation family farm with a residence and 5 outbuildings. 2 local teenagers stole his pickup truck for a joyride, and they abruptly learned that large trees don't move. The passenger died on impact, and the driver survived in a coma. The auto insurance was depleted, followed by the homeowner's insurance. Then the $1 million umbrella policy paid out, and all the insurances were exhausted. No more insurance, and Bill became uninsurable. All assets were separated from personal ownership before the wave of lawsuits hit. The lawsuits were limited in scope to assets owned by Bill, the owner of the truck. The family farm, the cash accounts, livestock, and property remained intact for the next generation of the family. This is really important to understand. Medicaid covers 100% of medical over exemption amount after your spend down. Medicaid spend down requires you to spend your money and your assets to an exempted amount, and then they cover the rest. Here's how it works. Maddie has a monthly income of $2,200 a month. The exclusion in her state is $1,750 a month. Monthly meds cost $2,600 a month. $2,600 cost minus exclusion of $1,750 means $450 is Maddie's spend down. Medicaid covers the balance and also covers additional medical expenses. That's her insurance policy for not having money or assets. This is based on the month-to-month income versus medical expense. If Maddie lost her job, her income would be zero, so Medicaid would cover 100% until income is restored. Countable asset limits vary by state, so you will need to look that up for your state. This is the amount of total countable assets and cash you are allowed to have and still qualify for Medicaid. Assets of greater value are required to be liquidated and spent before Medicaid will pay. Learn and understand what counts and what does not count. Learn how to move countable assets to non-countable status, all within the law and the rules. Fernelda, age 61, was recently widowed with expensive health issues. Without her husband's income and insurance, she has no money. She now owns 24 antique cars from her husband in prepaid storage with an ownership directive to the kids and grandkids, and a directive not to release any cars to the heirs until she dies. She separated the cars from her personal ownership, keeping control to not release the cars until a later date, so the cars no longer counted as her personal assets. Without the countable assets, she now qualified for Medicaid. Let's look at the strategies of the wealthy families of the world. Just file a lawsuit against any of them and you will discover you will never touch an asset they control. Their strategies have been proven for centuries. Let's copy them. Wealthy families pay the big bucks to separate assets from themselves personally. You can do it yourself or do it with help. Get help to learn what you need to know. Get help learning the how-to. Get coaching help to guide you in things that may be new to you. Asset preservation education is now affordable for the common folk. You can do it for less than a used car, and it will last a lifetime, unlike the used car. Preserving wealth is necessary if you plan to keep it, control it, or pass it on when retiring or dying. The wealthy families of the world have mastered this for centuries. We appreciate their examples so we can do the same. Educate yourself in the methods of the wealthy and then implement your knowledge. Have you ever been able to do something you had no knowledge about? It all starts with your education. I can't overstate how important your education is for this. Statutory entities are created and authorized by the state. You pay an annual fee to the state. These are all public record and open for anyone to see. Contracts are created by private parties. Contracts are not subject to the view or scrutiny of outsiders. Privacy is really good. The primary purpose for statutory entities is to identify which set of rules apply to your taxable events. We recommend keeping taxable events within the entity best suited for your tax purposes. Contracts are used for everything conceivable. Contracts can be used to protect assets while you build your wealth, and simple contracts are commonly used to transfer assets to the next generation. These are two different functions, and we focus only on protect assets. Documents and contracts are binding upon signature. Which ones do you need to achieve your goals? How do they work? You can hire someone to write them for you. You can use templates, which are readily available. You can even use a yellow pad and a pen to write your own. Anyone can write a contract. You may want a coach to guide you on the many options available. You will see why we call contracts the expanded toolbox, especially for protecting assets. There are templates for protecting banking, equity holding real estate, deed holding real estate, protected personal property, protected business property, non-disclosure and privacy, promissory note, and that's not all. This is part of the expanded toolbox. And the list goes on. and on with many, many more. Okay, let's do a true or false. My attorney makes everything legal. Is that true or false? That is actually false. Your signature is what binds you to a contract. You always represent yourself, with or without legal counsel or representation. Let's do another one. True or false? Hidden assets are safe because they are hidden. That's false. Every lawsuit is driven by a reward. Even hidden assets can be found. Payday for lawsuit comes with finding assets. Some treat it like a game of hide and seek. With a lot of practice, some get really good at finding assets. No need to hide when assets can be separated from ownership. Assets can be anything of value such as real estate, gold, silver, uncut diamonds, inventory, antiques, family heirlooms, and even intellectual property. Asset separation legally removes assets from the reach of the courts, consistent with and fully within the law. Only what you own counts as your asset. Can you use someone else's money? Sure. Do you own it? No. Can you live in a house you don't own? Sure. Do you own it? No. Can you borrow or rent a car? Sure. You don't own it. Can you use your employer's tools? Yeah, you can, but you don't own them. Asset forfeiture or asset seizure is a form of confiscation of assets by the state without evidence of wrongdoing, and evidence is never required until trial. Assets are often held indefinitely. The laws of taking assets are thorough and used often, while the process for returning assets is nearly non-existent. Frozen accounts are similar in that the money cannot be withdrawn or used. Funds remain in the account at the bank, and you can't access it. This is how common banking is done. Simple. You receive money and you deposit it to a personal or business account. All is well. Then you spend the money directly out of the account. All is still well. This is how you pay business expenses like payroll, overhead, cost of goods, profit, etc. And you also pay personal expenses like mortgage, utilities, household expenses. Maybe a little goes to savings, and all is well. Uh-oh, suddenly all is not well. Accounts are seized, frozen, or garnished. Suddenly your accounts stop paying out. You have no access to your money. Too late, you lose. Or you could use protected bank accounts. These have a different status and different rules than common checking or savings accounts. It takes contracts for the setup, but these accounts cannot be accessed the same as common accounts. Transfer all funds from common accounts to protected accounts and direct all future deposits to the protected accounts. And all is well. Once the money is in the protected account, it does not count as owned by you, and you can control it, so the distribution of payments cannot be stopped. All is well once again. Payment sent, payment delivery, all is well. Your credit is calculated based on your debts owed, your tax reported income, and your payment history. It is not affected by which bank account money goes into and out of. You can use a simple protected bank account or get as complex as you like. This example shows a structure that allows easy to follow and track money from start to exit. You have total control as a signer, yet you are not the owner of the funds in these accounts. No one can garnish, seize, or freeze when set up right. Remember, what you don't own does not count. All real property is subject to auction and sale for lenders, lien holders, contractors, collectors, IRS, and Medicaid recovery program. Only equity after all is paid out in proper sequence remains. Learn proven strategies to lock the equity and prevent Medicaid along with all others from having any claim. Learn and implement, or you risk forfeiting everything. The promissory note is a common financial instrument that has been used for many centuries. It may include face amount, the interest rate, and even a penalty for violation of the agreement, such as a non-disclosure clause. It should include all terms agreed upon by both parties. If there is no collateral, it is only a good faith agreement without any way to collect in the event of default. Collateral is anything of value that is pledged for the forfeit of ownership upon default and enforceable by court order. The creditor holds legal claim to the collateral until the note is satisfied. In this case, the creditor holds legal claim to, this is an extensive list, all property as collateral on this debt, including but not limited to all real property, all intellectual property, all personal property, all investments, and all bank account balances current and acquired in future until debt is paid in full. In other words, you don't get to own anything until you pay this debt, and no one else gets any until this debt is paid. What happens if you don't pay as agreed? You would be in default, and the collateral may be forfeited at any time, either voluntary or by enforcement. Then the next question becomes, who enforces the collection? How would it work if the trustee to this trust happens to also be the debtor? How much effort's going to go into that collection? What happens if the creditor forgives the note? The collateral claim would no longer hold a legal position, as if it never existed. That would make other liens and claims move forward in line to collect. Remember, the rule of collection has always been first in time is first in line. This trust name does not have any family or individual's name associated, nor does it have any identifiers to indicate who is attached to the trust. It doesn't really matter, but it does make it much more private. Remember, always double and triple verify the legal descriptions for accuracy, even when a title company does the work. An error on this will put the lien on the wrong property or even on a property that does not exist. How does this knowledge help with real estate? Let's highlight a few key things. In this example, the house is worth $400,000. There is a first mortgage for $300,000, so the creditor owns $300,000 of the $400,000. The first mortgage lender has the right to auction the property if necessary to extract their $300,000. The remainder goes to the next lien holder in line or the owner if any remains. 7 years down the line, the first mortgage for $300,000 is still there. The property went up in value by $268,000 in equity. The first mortgage lender still has the right to auction the property if necessary to extract their money, and the remainder still goes to pay the next in line. Or you could change this tomorrow so you control who is next in line. You could arrange a $5 million lien in second position. The first mortgage for $300,000 does not change. The first mortgage lender still holds the first rights to any auction proceeds to make them whole. The remainder goes to the next lien holder in line, which in this case may be a trust, LLC, S Corp, C Corp, mother-in-law, brother-in-law, friend, neighbor, etc., or the owner if any remains after that. Make sure you can trust the controller of the lien. Who can you trust more than yourself? You may want to be the signatory on controlling the lien. After all, who do you trust more? In this example, the house is now worth $881,000. The first mortgage is now only $150,000, so the creditor owns $150,000 of the $881,000. And the $5 million lien with compounding interest has doubled to $10 million. The first mortgage lender still has the first right to any auction proceeds. The remainder goes to the next lien holder in line, which is controlled by whoever was appointed. In this case, all remaining proceeds are insufficient to satisfy the debt owed. The controlling party is not the owner. In 30 years, the first mortgage is paid in full and no longer has a collateral interest in the property. The value has risen to $2.4 million. Meanwhile, the second moves into first position in line. That $10 million lien compounds to $20 million. All auction proceeds would apply to the $20 million note, leaving $17.6 million deficit to account for. And still, the controlling party is not the owner. And in this case, the property owner owes $17.6 million more than the property is worth. And yes, you can control the transaction of selling or transfer if you are the signatory, even if you're not the owner. Make sure to avoid fraudulent transfer or any appearance of possible fraud. Do not sell to a friend or relative, especially below value. Do not transfer direct to a trust or statutory entity without a friendly lien in place first. Make sure the contracts are accurate and in order. And you can live in the property as a non-owner for the rest of your life. The same rules apply for business and personal property as well. You don't own it, you don't count it, and they can't take it. Can you keep the family's inheritance away from Uncle Sam and others? Yeah, you can. Business and personal assets. You can remove court access as you retain control and use assets such as accounts receivables, accounts payables, cash on hand, furnishings, tools, equipment, inventory, proprietary processes, and even intellectual property. The wealthy families of the world have done this for centuries. Copy their example. Vehicles are considered personal property with the title at the DMV, which is public record and easy to find. Vehicles can be seized and sold at auction by court order, the same as any other property. In this example, the car is worth $30,000. It is fair game to take under court order to satisfy a judgment, subject to all prior dated liens. In this example, the vehicle is free and clear and is 100% at risk. This vehicle worth $30,000 can be sold at auction with the proceeds applied to a judgment. That does not mean it will be sold for $30,000. It means they sell for any discounted price the auction brings, and that amount is applied as payment on account. The remaining balance will be collected later, perhaps with another forced sale in the future. In the event there is a debt owed with the vehicle pledged as collateral, the lien holder must be satisfied before any proceeds can apply to the judgment. Any creditor forcing a sale would be required to cash out the lien holders ahead of them in line before title can be transferred, even at auction. Zero gain takes the motivation away from anyone wanting to take this. Personal property is now being held as collateral against a valid debt instrument. I am using stuff only until the repo happens, if ever. The collateral contract is dated prior to your judgment, therefore any attempt to take the property would be unlawful and would involve grand larceny, which is a felony. Is grand larceny a real thing? Yeah, it is. The sheriff will check with the legal staff and withdraw rather than commit a felony. The key is to do all the contracts and supporting documents 100% correctly. Coming soon, retire stress-free. This next one is not designed for the 5% with more wealth than they ever spend. It is for common folk to make life easier in retirement. The topics are, number 1, never outlive your money. Number 2, never outlive your housing. Those two are critical. Number 3, create hands-free passive income. 4, double your money in 3 to 8 years. The key part is without risk. Number 5, eliminate medical poverty in retirement years. And number 6, print new money legally. Control everything, own nothing. You can change the successors that manage and control at any time. You can change, add, or subtract beneficiaries at any time. Make sure the contracts are accurate and in order. Email any questions you have to assetconnections@gmail.com or to schedule a one-on-one personal evaluation.